Legally Speaking, with me Tarun Nangia. Justice Chandrachud, we did a series on him before he took over as the Chief Justice of India. And the series was targeted hope. There was a lot of hope. And as he took charge, we saw so many big decisions being taken. One among those was this decision that he will list 10 cases of bail daily before each bench, which will take this number up to more than 150 cases that will be heard. And in my own opinion and view, this is one of the biggest push for the Invest India program of the government. Why I say this? Because any investor in this country looks at how fast do they get access and redressal for the grievance. And bail is one of the most important things in the country, where we have known businessmen to languish in years without bail. From the lower court to the High Court to the Supreme Court, it takes a significant amount of time. But my panel, I have an eminent panel, and they will delve into this and share the details of this almost historic decision that Justice Chandrachud has taken, that every day 150 matters. It comes as a breath of fresh air and something to look forward to. May I introduce you my panel? I have with me Senior Advocate Amit Desai, eminent jurist, one of the leading counsels of India. Good to see you, Mr. Desai, and thank you for your time. I have with me Senior Advocate Pallav Shishodia, an eminent lawyer of this country. Good to see you, Mr. Shishodia. I have with me Advocate Abhimanyu Bhandari, who practices at the Delhi High Court and the Supreme Court and is an associate member of the Fourth Pump Court in the United Kingdom. Good to see you, Mr. Bhandari, and looking forward to some interesting inputs from you. At the outset, may I request Senior Advocate Amit Desai to lay the ground for what he thinks of this decision and its far-reaching impact before I move on to my other panelist. Over to you, Mr. Desai.
So Tarun, again, thank you for having me on this show. And as you have rightly mentioned, that this is a historic decision. I must tell you that in all my years of practice in this area, this is probably the first time that I have seen the Chief Justice actually give such a priority to personal liberty as has been done here, with the listing of 10 cases before every single bench. And I think at the target of it, disposing of about 650 to 700 bail applications every week from now till Christmas. And that is going to be a huge, huge relief. But let me sort of step back a little bit here, Tarun, because we talk about this in the context of Invest India program. And I think in the past, we've actually spoken about many facets of this issue, which have troubled Indian business and Indian industry. And let me sort of give you a context, because I think it is cataclysmic as to what is happening in the judiciary over the last few months. Let me give you a set of facts which will tell you what's really happening. On the 11th of July of this year, and these are all events that you will see of the last 4 or 5 months, it shows the anguish of the Supreme Court. On 11th of July, we have a seminal judgment delivered by the bench of Justice Paul and Justice Sundaresh, which is known as the Satinder Antil judgment, which was an attempt by the Supreme Court, which was itself anguished by the number of bail cases and people languishing in custody, to lay down guidelines as to how the trial courts would deal with bail applications, and reaffirming the principle that bail is the rule and jail is the exception. Now you see this as a trend line from the 11th of July of this year. What you then have is a observation by the erstwhile Chief Justice, Justice Ramanna, on the 18th of July, when in a program addressing the district judiciary, he said process is a punishment, apart from many other things. And he brought to the forefront, once again, that what's happening to the criminal justice system in this country, that process is a punishment because people are just languishing in jail and they're not in a position to get out, and there's a pre-trial punishment. What you then saw was Chief Justice Chandrachud, as he then was, on the 31st of July, again addressing the legal aid officers, where once again emphasized the problem about accused lying, languishing in jail. And I must tell you that he then said, reaffirmed the principle that bail is the rule and jail is the exception, and made a comment to say that every day's custody in jail is inappropriate and takes away personal liberty. So once again, on the 31st of July, you had this message that was going out from the highest levels in the institution of the judiciary to say that please focus on this principle of bail, not jail, and take up these matters. In fact, in Satyendra, until they said ordinarily bail applications should be disposed of within 2 weeks of the filing of the bail application. These are guidelines which are settled, and the Supreme Court is monitoring this process. You then had, I would say, Chief Justice Lalit. When Chief Justice Lalit came in, you should see the comments that Chief Justice Lalit has made and his own conduct in releasing people on bail. And then he introduced this whole concept of public defender. And then very recently, just this Monday, he was the main speaker at the KT Desai Memorial Lecture in Mumbai, and where the topic was again criminal justice and reform in criminal justice. And the main issue that he again focused was on the reality of what's happening in the jails, the overcrowding of jails, the re-emphasis of the need for people to come out on bail. And as that was happening, we had Chief Justice Chandrachud make one more comment where he then said that his apprehension is that the district judges are not granting bail because they feel that they're being targeted. There's a very, very strong message to the judiciary to say that please pass orders of bail without fear. The Chief Justice of the Bombay High Court, again at the KT Desai Memorial Lecture, re-emphasized and sent a message to all his brother and sister judges and the subordinate judiciary to say, please pass bail orders without fear, you will not be targeted. Now, when you then have Chief Justice Chandrachud then saying, I will now list 650 to 700 matters every week, because the docket of the Supreme Court, 40% of the docket today is criminal cases and bail matters. Now, you need to therefore, deal, because ultimately for all these years, we've been talking about personal liberty, but we can't do lip service to personal liberty. Personal liberty is something that has to be actually acted upon. So I am now very hopeful that in this 6 weeks period, the Supreme Court will pass bail orders on the principle of bail, not jail, which was something that was set down by Justice Krishna Iyer in the mid-70s, and which in some ways has been forgotten in the last 7 or 8 years. There is a need to continuously re-emphasize, and I just do hope that the court will now be liberal in granting bails, and that is the message that the Supreme Court would send down to the high courts, because there are a large number, I've got the statistics I'll tell you later on, large number of bail applications in the high court and even larger number of bail applications in the trial court. So what you're seeing is in the last 5 to 6 months, and please bear in mind, an interesting intervention that happened here is that on the 27th of July, we had the famous PMLA judgment. Now, this is the balance, because when we have the PMLA judgment, which took a view on 45-2, on which has been discussed and analyzed and debated on your show for a long period of time, and there was a concern about the whole interpretation, the question of the law of bail. You see the observations and the comments of the Chief Justices of the Supreme Court before and after that judgment is about the re-emphasis on the question of personal liberty. And therefore, in a sense, as Justice Lalit mentioned at the KT Desai Memorial, saying that probably the Nikesh Tarachand was a pointer really in the direction of how these matters should be considered. So it's telling you that the judiciary at the highest levels is very, very concerned about the problem. They feel the need to resolve the problem. And I do hope that in the next few weeks and months, we will see a very positive outflow, because when I started my career, a bail application used to take 15 to 20 minutes. Today, a bail application takes days on end to argue. And that's not what is the intent of the criminal justice system, which I can talk about a little later.
Thanks so much for that introductory comment and the explanation that you gave the viewers. I'll go across to Senior Advocate Pallav Shishodia for his opening comment.
No, I would join Amit in welcoming this move by Chief Justice Chandrachud. In fact, today we have a situation in Supreme Court that for offenses like 420, which are compoundable, you don't get bail in high courts, and the matters have to come to Supreme Court. And this is one reason that there is a kind of explosion of bail applications or the matters, special leave petitions or the appeals arising out of denial of bail to the accused. Of course, there are some matters where the state is coming against grant of bail, which is also very unusual. So with this kind of explosion and with this kind of somehow a kind of atmosphere in the country where the bail is becoming difficult even at High Court level, and even for offences which are essentially of civil nature. So this is really a welcome step. But I must tell you that over last 30 years, I've been practicing in Supreme Court. The different Chief Justices come and they make experiment according to the need of the time, their own sense of priority, or some other factors. And the roster or the listing system, etc., keep on changing. And so in that continuum, this kind of experiment is also a welcome experiment because this is needed. And this is, I mean, the way Amit has emphasized, I don't need to add to that. It is really needed because the whole bail jurisprudence is going for a toss. But I must also add a note of concern that listing or early hearings, etc., are more matters of procedure. But there are some substantive issues like the review of PMLA judgment now, because this judgment which has come and which has sort of re-inducted Section 45 in PMLA Act, contrary to the earlier judgment in Nikesh Tarachan, overruling that judgment. Matters like this should be considered so that the law is also laid down and correctly followed throughout the country. Because today, even if there is an early listing, but if it is a matter concerning PMLA, and forget PMLA, Companies Act, Section 216, or where you know the same parameters for bail are there, it is very difficult to get bail even if the matter is listed. So this has to be addressed at the institutional level, and the criteria for bail, especially in matters which are essentially of civil nature, or say the corporate frauds or the corporate offenses, they should be again revisited, and the law should be straightened.
Thank you so much for explaining this and also sharing your insights on bail in twin condition under PMLA, which you highlighted via the Nikesh Tarachan Shah judgment. Very interestingly, currently the judge has to record a finding that the accused person is innocent before granting him bail. That is quite absurd, actually, but that we have addressed. In fact, I remember Advocate Abhimanyu Bhandari speaking on that some time back. Senior Advocate Amit Desai also articulated. Over to you, Mr. Bhandari, and your opening comment.
Well, Tarun, I think the fact that now the Honorable, the new Chief Justice, has come out with this circular, which clearly says that there will be a definite number of bail petitions which will be listed every day, which will culminate into a number of petitions every week. I think since I've been practicing in Supreme Court, this is the first time I've seen that. And that is a very, very positive indication, because that tells us and tells everybody in our country that, look, Supreme Court is serious about personal liberty, as Mr. Desai rightly said, and as Mr. Sishodia rightly said. So I think the fact that today now we live in an environment where the Honorable, the Chief Justice, has said that, no, we are going to list it, and everyday bail petitions will be listed, shows that the priority is that people will get an opportunity for their bail petitions to be argued. Now, we all know about this circular, but what is also very interesting is that Supreme Court has also simultaneously, under the new Chief Justice, come out with a rule that if you file a bail petition or any petition, let's say you file it on Friday or Thursday, within a definite period, that new matter will get listed. So it's not like you file it and you wait for days for that matter to be listed. Tarun, I, from a personal experience, did an economic bail matter of some time back. And we filed it, and it took a really long time for that matter to actually get listed. But now, under the new system, if you file a fresh matter, then it will definitely get listed within a definite period of time. So therefore, I think these two things together is a very positive indication for personal liberty. Second, coupled with this, The fact that we heard the Honorable Chief Justice say that district courts many times don't grant bail because of fear of being attacked shows that the higher judiciary and the apex court is alive to this issue. And this is the most critical issue, why there is a docket explosion of bails in the Supreme Court. Look, I'm going to keep away my points on the PMLA a bit aside, because I've shared that many times. There are, other offenses also, and people are not getting bail. And they're not getting bail because whether it's a PMLA or not a PMLA, the minute an amount involved is large, the minute the crime is heinous, the subordinate judiciary judges come under fierce pressure that if they grant bail, they will be attacked. And this is what the Honorable Chief Justice said. And, this was something that he said, and it was really needed because, I go to trial courts a lot for arguing bails. And I get a sense of feeling that aside from Delhi, in other parts of our country, there is this whole kind of unsaid rule. Oh, the amount involved is very big. Don't bother wasting your time here. Go to High Court, And I think the fact that the Honorable Chief Justice said that, look, they are getting, they're under the fear of being attacked is very important, because that will give confidence now to a lot. What the Supreme Court says has a huge impact on judges in the subordinate judiciary in the High Court. So I think it's a great thing that we've seen this push. We are living in a world, Tarun, between the Antil judgment and the Vijay Madan Lal judgment. The Antil judgment, which just a couple of months before, a few weeks before Vijay Madan Lal, I think cited Nikesh Tarachand. And then we have Vijay Madan Lal, which says Nikesh Tarachand is not good law. And we live between those two judgments, one which is seen as one of the most progressive judgments in the bail jurisprudence, the Antil judgment. And let me tell you, with the Antil judgment, a large number of cases which would have come to Supreme Court will now not come, because a lot of the courts, and Mr. Desai, Mr. Sishodia, we are accustomed to being in Delhi or Bombay, where you see courts still, giving you bail. In other parts of the country, even if you're not arrested and a charge sheet has been filed, people have to go to a High Court, file for an anticipatory bail before they appear when summons are issued to them, because the fear is that the subordinate court will actually not grant them bail, rather take them into custody, notwithstanding that the investigating agency doesn't want to take them into custody. But comes Antil and clarifies that entire area of law, which I think has helped immensely in ensuring that the High Court and the Supreme Court are less burdened with such bail applications. A number of these bail applications were not bail applications where people were arrested before charge sheet was filed, but also was cases where people were taken into custody after charge sheet was filed. So I think the Antil judgment, coupled with the fact that we are now going to have a system where there are going to be at least 10 or definite number of bail petitions listed every day, will really ensure that personal liberty is put at the forefront.
Thanks so much for explaining that issue to us, Mr. Bhandari. I'll go across to Senior Advocate Amit Desai. Very interestingly, if there is a news in the media that a scam is worth 20,000 crores, 15,000 crores, sometimes it's very difficult to get bail. Secondly, when the charge sheet is filed, the allegation may be of 100, 150 crores against the news media report of it saying 15,000 crores. Do you think sometimes a lot of hysteria in the media with motivated leaks also leads to prejudicing the mind of the courts, where there is huge hysteria and the lawyers have a very difficult time defending at those times? What do you think about that?
Tarun, you've touched upon a topic which really causes a lot of concern to all of us at the bar. You're absolutely right. It is the hysteria, as you use that correct term, which is created by the media, because you get large TRPs based upon the number, because it's very nice to actually put a whole lot of zeros in a newspaper, which is so mind-boggling that nobody will have the courage to actually deal with a matter of that type. And what we have seen, and I've seen this over the years, and I'll go back actually to the 2G matter, where I was also very closely associated. And I still remember that the whole media had carried out a campaign that it was a 1,76,000 crore case, right? And therefore, none of them got bail for 6 months till ultimately the Supreme Court granted the bail in that matter. But when you actually looked at the fine print of that matter, ultimately, what was that case about? 1,650 crores was the amount in relation to one particular license. So when you started the hysteria at 1,76,000 crores, and therefore nobody got bail, and when you look at the actual proceedings in the trial, and what was the evidence that was led in the trial, it was in relation to one license, and the license fee was 1,650 crores. Now, this is the problem that we face, and this is something more so in the last few years, where now that we have the IBC and every case is going into investigation on fraud and there's a forensic, and every matter, while there is a liability to the banks, which will be 10,000 and 20,000 and 30,000, the contention is that the fraud is equal to the liability. If we actually go down to the principles of criminal law, large part of it is purely a civil dispute between the bank and the lender and the borrower. And maybe there may be a smaller part of that entire amount where there may be an element of criminality that takes place. What is happening now, and what has happened in this period, is bank suits are dead. Bank suits used to be filed because there would be a dispute of a civil nature between the borrower and the lender in relation to the liability and the interest claim and the penal interest. But now that these cases are getting filed, out of fear, the bank suits are becoming less relevant because everybody is now worried. He says, sorry, let's just go and pay up. And no court, no civil court, be it the DRT now want to be able to look at the matter objectively to say that what exactly is the amount which is due and liable and payable. Now, in this whole process, you're right that, the justice system and the bail law has gone upturned because nobody has, as I would say that Chief Justice Chandrachud's concern, and I'm glad that he has voiced it publicly, is that there's a perception amongst the judiciary, which is the first line, which deals with the remands of accused, that they may be targeted because if they grant bail. I'll give you an interesting point of view here, Tarun. Please assess in how many cases across the length and breadth of India has disciplinary action been taken for a judge who has refused to grant bail. It's a very telling circumstance. None. It is only when a judge grants bail that there is a potential disciplinary inquiry. Why? The law on bail is well settled for the last 70, 80 years, maybe more. The principles are well settled, reaffirmed by Justice Krishna when he remarked bail, not jail. And how many are following them? Now, should that also, if you fail to grant bail in terms of the law laid down by the Supreme Court, is that also not a cause for something? But why is it that there is an action? And that's why I'm very happy at what I heard the other day, at least from the Chief Justice of the Bombay High Court, where following up on the observation of Chief Justice Chandrachud, he, in the presence of his brother and sister judges and other district judges, has urged them that please pass your orders without fear. Don't worry, no disciplinary action. And this was a public statement made on Monday. Now, this is necessary in order to give the courage to this hysteria, because I'll tell you, and I can just spend 2 minutes more on this. What is the requirement of a trial court when an accused is presented before him for bail? Settled principle affirmed and reaffirmed by the Supreme Court. Your first duty to see whether the arrest was necessary. How many judges, despite the law is laid down, actually go into the question, was the arrest necessary? And this principle has been reaffirmed in until. In fact, that was a matter which I had argued before Justice Call, and he was actually very open-minded to say that we need to find ways to simplify this entire process. Reaffirm the principle that your first duty is the arrest lawful. And I must say that in the recent order of Justice Deshpande, when he granted bail to Mr. Raut, he has reaffirmed that principle. That your first duty, now if the judge determines that arrest is not necessary, then custody is not there, automatically the people are out on bail. But how many judges fulfill that first duty? These are all settled.
Very well taken. I'm requesting one 30-second comment from you before moving on to Senior Advocate Pallav Shishodia. With the decision Justice Chandrachud has taken, what do you think is the message to the investors community in India? Because they closely look at these things.
I'm saying that I'm looking for the second message. This is a very, very powerful message. And in fact, when you talk about business crimes, and as Pallav rightly said, we are seeing that business crimes, which are all these cases of cheating and some breach of trust and all, which are quasi-civil, quasi-criminal, but largely in today's day, I'm saying largely civil and not so much about criminal. These are all recovery mechanisms which have happened in the banking system. If this message goes, then investors may come back, because there is a fear amongst investors that commercial disputes are getting settled in police stations.
Yes.
And they don't have the ability to point out their point of view on a contract or a breach of contract because of the fear that they'll be arrested. This message is important, but there's a second part to it, which is as if not more important, is the trend line of the Supreme Court granting bail in these kind of matters. If that is by orders, and we have probably several thousand matters will get listed between now and end of December, if we are looking at about 650 to 700 matters a week, one must see that also the Supreme Court is then looking at this principle and encouraging the lower courts, high courts, trial courts to grant bail without fear.
Very important. 600, 700 matters a week for bail.
Yeah, and that's several thousand by the time we have the Christmas vacation.
Thanks for that input. I'll go across to Senior Advocate Pallav Sisodia for his comment A on the investment climate. Secondly, the impact of this, in a sense, decision by the Chief Justice of India.
No, you see, all investors would look at how does it pan out. And if it does really follow the course which we all anticipate, in a more liberal regime of bail, it would definitely inspire confidence among investors that India is not a country where you can be put behind bar or the police can pressurize you to settle your business disputes in a under pain of arrest or things like that. And in fact, we come across nowadays a lot of cases where the money which has changed hands in course of business, and there are some disputes about the liability, and people would prefer, because see, in a civil suit, you have to pay court fees, you have to wait for your turn, it takes long time, or even arbitrations can also be lengthy and expensive. So people go to police station, lodge an FIR, activate the police machinery, and are able to settle the dispute very quickly. And some of the people who are adamant, sometimes they suffer the consequences. So this is something which has to be discouraged. And a liberal regime of bail, and once it goes out that no, the bail would be granted, and in any case, the matters listed in Supreme Court would be taken up very fast. This would definitely improve the business investment sentiment and attract the investors more to get into in our country.
Thanks for that input. I'll go across to Advocate Abhimanyu Bhandari. Mr. Bhandari, if you say, for the example of the City of London, if an investor is worried that his company runs in India, a warrant is issued, for example, in a district court in UP, because some vendor of his or some employee of his there in India has entered into some kind of dispute with one of the buyers or the vendors. The point being discussed here is that this fear that you can be fixed and thrown in jail and even still later be found acquitted and having spent 2 years in an offense which may have carried a jail term of say 6 or 7 years. What I want to know from you is that, do you feel a lot of people are fearing that, and some may have even fled the country fearing that even though they may be acquitted eventually, they may be fixed much before that. They have to spend 2-3 years in jail and then they get acquitted. Their whole life is in a country where companies are promoter driven. If the promoter is inside, the company collapses. Your inputs on that.
Tarun, no promoter would like to spend 2 years in jail. Forget about 2 years. No promoter would like to go into prison even for a day or for 10 days. And I think promoter and business investors now understand that once you are arrested, and it can take days before you can get bail. If the trial court doesn't give you bail, you have to go to high court. High court will take some time because, notice will be issued to the public prosecutor and a date will be given. So it's not like getting bail on the same day. The practice, of course, in European countries and in UK and US is that such offenses are bailable and you get bail on day one from the magistrate's court, if not from the police station itself. So therefore, you can't just compare both the systems. In our system, it's becoming increasingly difficult to get bail for economic offenses. And the problem is that the bigger the numbers, the more difficult it is. So for example, there could be a real fraud for 5 lakh rupees. And there could be actually an actual business loss of 100 crores. But just because the 100 crores sounds 100 crore and you have investigating agencies against you under the PMLA Act, under the Companies Act, under the Black Money Act, all with these rigorous bail conditions, therefore getting bail can be a nightmare. And that's one of the issues that is really, really troubling everybody. I see no reason why we should have those twin conditions, or really, I don't call it the twin conditions, but I call it that one condition that the court has to be satisfied that the person has not committed any offense. Under the Companies Act or under the PMLA Act, the PMLA offense is a 7-year offense. It's just like a 420 offense. And therefore, one should be able to, and therefore I think that it is time we get the jurisprudence of Nikesh Tarachand again reaffirmed. And I hope that the matter which is pending in Supreme Court is taken up sooner than later. And, you know, there is some hope because as Mr. Desai says, we've had this one big news. I hope there is a new big news coming in where we see some of these principles of jurisprudence being settled in, as Mr. Shishodia pointed out. So I think while it is very good, and I think we have moved a big leap forward with the Antil judgment, we moved that bigger leap forward with the fact that 10 bail petitions will be listed on each 5 days in every day in the court. I think we could move really miles ahead if we soon get the courts for once and for all telling us that whether these twin conditions should survive in today's jurisprudence. And I think we've, as a nation, and and our people who are in the business community have seen the 2G saga, right? And I think we should learn our lessons from the 2G saga. That if it is 1,76,000 crores can also, that it sounds draconian, but eventually it can lead to an acquittal. And there is no need to keep anyone behind bars. Today, if we had the 2G saga in today's time, I think those people who suffered were lucky that they got bail in 6 months. I wouldn't see them getting bail in 2 years with the kind of conditions that we have today. They eventually may have acquitted themselves, but they would have spent a much longer time in today's times than what they spent in, when this whole 2G scam took place, because the IPC offenses never had the rigors and the shackles of the twin conditions. So according to me, and twin conditions are not only in the PMLA, they are in the Companies Act, as Mr. Shishodia pointed out. So we are living in a situation where getting bail is becoming more and more difficult, especially in economic offenses. And people are able to settle their inter-se rivalry without going to a court of law in a civil dispute or in an arbitration or any civil method by actually using the investigating agencies to fight their war. And we as a country can't afford this. And therefore, I think it is high time that we make it a rule that and I also don't see, Tarun, that a businessman who must have built a business over 10 years, 15 years, and let's say his business collapses and everybody says that he's a fraud, he's a fraud, he's a fraud. I don't see that even if it is a big number, after charge sheet has been filed and investigation is complete, why should that person remain behind bars? I mean, before he was arrested, he was in the business community for many years doing business. So I don't see that. I can understand in a heinous crime like murder or where someone has killed a number of people, you want to protect the society from a violent person. But in a business community where where investigating agencies have powers of attachment, have powers of seizure, have powers of taking over even possession of assets, even before a complaint has been filed in a court, then in such an environment, I see no reason why bail should not be granted. And it is important that businessmen are given bail so that they can come out. And let me tell you, keeping businessmen behind bars and imposing draconian conditions doesn't resolve the plight of the creditors. I haven't seen any situation whereby taking a businessman behind bars, you're able to solve the creditor problem. That means the creditors who are owed money by that businesses have been repaid. Rather, I've seen that go down, has become more difficult. So therefore, if you take into consideration these policy, these factors, I think it is high time that we hope that and pray that the courts realize that the jurisprudence of Nikesh Tara Chand was spot on, and we come back to those days.
Thanks for that input, and thank you so much all to my panelists for joining in today at a short notice on this really important issue. Indeed, the decision that Justice Chandrachud has taken is far-reaching. 600 or so, or maybe more, bail matters listed before the Supreme Court will go a long way in sending a message to the investor community that India is a place to do business. Matters are heard here. You don't have to be forever waiting for your bail plea to be heard. That is indeed very reassuring and a great, in a sense, thumbs up to invest in India. I would like to thank Senior Advocate Amit Desai, Senior Advocate Pallav Shishodia, Advocate Abhimanyu Bhandari for joining me on this show and explaining the impacts of decision. And so thank you so much, viewers, for joining us. Thank you so very much.